Welcome to those of you that have joined us. We have just opened the link, so we're just waiting for a few minutes to allow everybody to join us before we start. Welcome to those of you that have joined us. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Welcome to the Five Stone Buildings webinar program. We have just opened the live link, so we're just waiting for a few minutes to allow everybody to join before we start. Whilst we are waiting, I shall just remind you of the house rules. Just to remind you that this webinar is being recorded. If you have any questions throughout this webinar, please put your questions into the Q&A box at the bottom, and our speaker will try to come to them at the end if we have time. If you do not wish to be identified when asking your question, then please tick the anonymous box so that our speaker will not identify you in their response. And just to remind you that on the Five Stone Buildings website, we now have a separate section just for webinars where you'll be able to find the recording of this webinar and any slides used during the presentation. And I will now hand over to Jordan.
Thank you, Jo. Well, thank you all for joining today. What I'm planning on talking about is CPR 21 and approval of compromises on behalf of protected parties and children. I appreciate that on its face, it's not a particularly sexy or exciting topic, but it is one I think that comes up quite a lot in practice, and I'm sure many of you will have had it, and it can often raise well, maybe not thorny, but kind of tedious issues. First, because of the issue of who is in fact a protected party and how the problems that can throw up, particularly I think when you have older litigants who may be borderline. And it's quite important because there is an increasing focus on this, that you do give due consideration to whether or not someone is in fact a protected party. So that's the first thing that I'm going to discuss. The other issue, I think, with CPR 21 and approval of compromises is that it's not really drafted, although it's applicable, it's not really drafted for the areas of practice which many of us deal with. And that can also throw up issues. So that's the reason that I chose to discuss this. One of the things that's also brought it to the fore is I've had quite a lot of CPR 21 approval hearings recently, and that it has thrown up there that how differing judges and differing courts' approach can be. And so I think the kind of old laissez-faire approach to CPR 21 has perhaps gone by the by. Okay, so with that introduction as to why I'm going to speak, the first thing that I want to talk about then is who in fact needs a litigation friend, because of course CPR 21 is concerned with litigation friends and those who lack capacity. So there are two categories of people who can't conduct litigation on their own behalf. The first, and that's at CPR 21.12b, are children, which obviously is any person under the age of 18. However, it is worth mentioning that the court can order that a child can conduct proceedings on their own without the need for a litigation friend. In reality, that power is infrequently used, but it is sometimes used, particularly in the case of 17-year-olds, if they're likely to turn 18 during the course of proceedings. So it is worth thinking about that if that's your situation. The second, which is at CPR 21.12d, is a protected party. And that's a party or an intended party who lacks capacity to conduct the proceedings. Now, thankfully, at CPR 21.12c, the term lacks capacity is aligned with the Mental Capacity Act 2005 test. And so, of course, as with all other areas of capacity, whether a person lacks capacity to conduct litigation is issue specific. And so that means that I take that from section 3 of the Mental Capacity Act 2005, which I'm sure many of you will be familiar with. But that means that there's no such thing as a general litigation capacity. So it's capacity to conduct the actual proceedings that are involved. So it's not the case, for example, that somebody will simply have litigation capacity in respect of all proceedings. I mean, they may well do, but it's not necessarily the case that somebody will have litigation capacity in respect of all proceedings. So, for example, if you have something very simple, like a possession hearing or something like that, then it may well be that somebody has litigation capacity, but they wouldn't have litigation capacity into more complex and involved proceedings. And Dunhill-Bergen, which is a 2014 case decided in the Supreme Court, with which some of you may be familiar, for present purposes, it's interesting to note from that case, and important to note from that case, that what the Supreme Court said there was that the test as to whether someone has litigation capacity is a test of whether the person has capacity to conduct the claim that he or she actually has, and not the claim as formulated by his or her lawyers. So I think that is quite important, because if, for example, the claim is overcomplicated by lawyers, and therefore they're complicated proceedings which somebody who's on the threshold of capacity may not understand, and you appoint a litigation friend, and it's later found that the proceedings were in fact misformulated because they're a much more simple claim, then you could have a problem, because somebody could have been acting on behalf of somebody who's not in fact a protected party. And of course, the converse is true as well. So it is important right at the outset, if there's any issues over whether or not your client is in fact a protected party, to really narrow down and drill down rather, and get to the bottom of what the claim is in fact about, in order that you can formulate the question properly as to whether or not your client is a protected party and needs a litigation friend. And if it, as I said there, if it falls within either category, subject to what I said about children, then a protected party or a child does need a litigation friend. So what can be one of the most difficult questions for the purposes of CPR 21 is, when does an adult who would otherwise have capacity lack litigation capacity? Now, it's often the case that Masterman and Lister is referred to, and Masterman and Lister is in fact still good law, and in Bailey and Warren, the case which I've quoted from on that slide, was cited with approval by the Court of Appeal. But in lots of ways, Masterman and Lister, which is an older authority, a pre-2005 authority, Mental Capacity Act 2005 authority, is less detailed than more modern authorities. So Bailey and Warren, I think, is possibly the best place to look for how you approach whether or not an adult lacks litigation capacity. And you can see, I don't propose to read out everything that's said on that slide, which is quite a lengthy and dense quote from Lady Justice Arden, as she then was. But you can see from that how high it can be, the threshold for somebody to actually have litigation capacity. And in my experience, except for the very simple proceedings, litigation capacity tends to be one of the highest levels of capacity you can have. So in that, that's illustrated by the matters which Lady Justice Arden said you would need, and she says that these are only some of the matters that would be considered in assessing a client's capacity. But I think I counted 6, with then some sub-issues as to 6. So the first is that the client needs to understand how the proceedings are to be funded, i.e. who's going to pay. Needs to know about the second is needs to know about the chances of not succeeding. So, you know, being able to understand what happens if they lose the proceedings. 3, the risks of an adverse costs order. 4, need to have capacity to make the sort of decisions that arise in litigation. Now, that's a bit of a cop-out, but it does emphasize that, of course, there's a lot of nuanced decisions that do arise in litigation, and particularly at various points in litigation, there can be a lot of decisions in quite a short period and that need to be taken in short order. And that can be a problem for more aged litigants. Number 5 then is the capacity to give proper instructions for and to approve the particulars of claim, and of course that follows all subsequent pleadings in a defence if they're a defendant. 6 then is capacity to approve a compromise, and this was something that arose in a case that I had earlier, because what had been said in that case by solicitors for one of the parties was that they did have capacity, but they didn't have capacity to approve a compromise, which I thought was interesting because, of course, Bailey and Warren establishes that you either have capacity for the lot or you don't have capacity for the proceedings. Because, of course, capacity to approve a compromise is in lots of ways much more nuanced, and that was recognised, as you can see from this quotation, by Lady Justice Arden, when she indicated some of the matters in order to approve a compromise that would be necessary, including ability to instruct solicitors to advise on the compromise, an understanding of that advice, and ability to weigh the advice. And I think this is what can be quite difficult. Need to know what he was giving up and what would happen if you refused to accept the offer of compromise. It's the weighting at that level that can make capacity to compromise quite difficult. But I think what is very important about Bailey and Warren is that it is an overall test as to whether or not you either have litigation capacity in respect of the specific proceedings or you don't. You don't have, for example, capacity to approve the particulars of claim or capacity to do everything but approve a compromise, because if you don't have capacity to approve a compromise, then you don't have capacity to conduct litigation, and you do need a litigation friend. Now, obviously, this doesn't arise in respect of claims by and against children, because they are incapacitous by virtue of the fact that they are under 18. So then, sticking with protected parties and the application of the capacity test, theoretically, P, and I've used the terminology P there, which is actually the terminology of the Court of Protection, but I should probably have used protected party. But a protected party may have litigation capacity, although of course they wouldn't then be a protected party, notwithstanding that they don't have capacity in relation to the subject matter of the litigation. So for example, if you're litigating about whether or not somebody had capacity to make a gift, it is theoretically possible that that person may have lacked capacity to make the gift, but they may nonetheless have litigation capacity to argue, to pursue or defend those proceedings. Now, in London Borough of Redbridge and G, Ms. Justice Russell thought that it would be highly unusual, and it's difficult not to agree with her in relation to that. The only circumstances, it seems to me, that you're likely to come across where somebody has litigation capacity, notwithstanding that they didn't have capacity in relation to the subject matter of the litigation, is if you have a client with fluctuating capacity, in particular clients who may have a schizophrenic condition or something similar, where if, for example, they're in a manic episode, they may lack capacity. So if they were in a manic episode at the time that they made the gift, but they're no longer in a manic episode, they could have regained capacity. I think apart from that, it's actually quite difficult to envisage of circumstances in which that would apply. But D and R, which was a decision of Mr. Justice Henderson, as he then was, is an interesting case and a template, really, of how you need to be careful when you bring these kind of claims. So what happened in that case was that somebody brought proceedings on behalf of a purported protected party via a litigation friend. and then the protected party themselves then brought an application to discontinue those proceedings. And what the court had to decide was whether or not they were in fact a protected party, and in doing so considered the capacity which is necessary in proceedings. These were undue influence proceedings where where there's a kind of a vitiating factor. If you're setting aside a transaction, which of course we very frequently are, often a gift or a transfer of some kind, if it's that kind of proceedings where you're looking at the vitiating factor, which of course could be undue influence, it could be mistake, it could be lack of capacity, then the litigant needs to understand the nature of that vitiating factor and to be able to weigh up the arguments for or against pursuing the claim. Now, there's a caveat to that, because somebody the other day who was talking about this case said, oh well, and therefore if somebody is being unduly influenced, they will lack capacity. But that's in fact not correct. So for example, if you have a client who is or if you have the subject matter of the proceedings, if it's said that they were unduly influenced into making a gift or a transfer, then if they can understand the concept of undue influence and weigh up the arguments for and against pursuing the claim, so they understand that somebody could be subject to someone's influence and may not be able to make an independent decision as a result of that, and they understand that if they don't pursue the claim, that they will lose what is otherwise a valuable asset, etc., etc., then they will have capacity, even if they are still subject to the undue influence of the person, of the undue influence in respect of the transaction. So, and there may be other things that you can do, which would be the subject of another talk, if that were the case, but it wouldn't rob them of capacity. And that's why the court said that providing that P, and I'm sticking with that terminology, is equipped to make the decision, it makes no difference whether he makes an imprudent decision or a decision which would not be in his best interests. So for example, if he says, look, I understand what undue influence is, I know that if I pursue these proceedings, I might have good prospects to get back the house that I gave to the person, but I don't want to do so. Now that you might think is an imprudent or unwise decision, but nonetheless, it doesn't rob that person of capacity and they wouldn't become a protected party. So if your client is the person who's proposing to be a litigation friend, then that's pretty much the end of the road in terms of bringing proceedings on behalf of the person who may or may not have been unduly influenced. So then, who may act as a litigation friend? Well, without a court order, there are two categories of persons who may act as a litigation friend, and they're set out at CPR 21.4. The first is a deputy appointed by the Court of Protection with the power to conduct proceedings on the protected party's behalf. Now, this won't apply to a child unless the child is likely to lack capacity at 18, and in which case they may have had a deputy appointed. So, for example, as is frequently the case, if a child has been the subject of medical negligence or has other mental disabilities or something like that, and it's likely, and they have substantial assets, and it's likely, therefore, that they will never have capacity, or they will gain capacity not at 18, but at a later date, then it may well be that the Court of Protection has appointed a deputy for them. But what's important about that is it has to be a deputy appointed with power to conduct the proceedings on the protected party's behalf. And unlike an attorney, most deputies do not have that power. It requires a specific provision in the order appointing the deputy. And that's usually only done at the initial stage of appointing a deputy, if they've been appointed in circumstances where it's likely that P is going to become involved in litigation, i.e. maybe there's been some financial abuse or something like that. The second and more common category of person who acts as a litigation friend for either a child or a protected party is a person who can fairly / competently conduct proceedings on the protected party's behalf, and has no adverse interest. And if the protected party is a claimant, which is often the case in these cases, undertakes to pay any costs which the protected party may be ordered to pay. And that's quite important because, of course, it means that the litigation friend is essentially saying it is taking the risk away from the protected party and is saying, actually, if there's an adverse costs order, I'm going to pay that from my own funds rather than from the funds of the protected party. Now, litigation friend does have a right on application to recover reasonable costs and expenses from any sum recovered, but subject to exceptions, and I will discuss those later because these are often very important when the protected party is a claimant. This will not include any costs which are disallowed on assessment. So, for example, as we all know, the assessment gap is usually considerable, and so the unassessed costs then would have to be borne by the litigation friend in any event, even if the protected party had been successful. And of course, it provides no protection if the protected party is unsuccessful, and it will leave the litigation friend having to pay all of the costs. What you can do, just before moving on to compromise, what can be quite important is that if you are dealing with an adult protected party in these circumstances, is that can obviously be quite an unattractive prospect for a potential litigation friend. And so what's usually the appropriate thing to do in those circumstances, if the protected party is not, does not have an attorney who can conduct proceedings without the authorization of the Court of Protection, would be for them to seek the authorization of the Court of Protection to conduct the proceedings on behalf of the protected party. And then, sorry, Joe, I think, sorry about that. Joe, I think we've got some feedback from you because I think you might be signed in twice. And one of the microphones isn't muted. I think I can hear you. There we go. Yes, and I think that in those circumstances, they haven't got an attorney because an attorney does have a right to conduct proceedings without the authorization of the Court of Protection. Then the thing to do is to apply to the court to get authorization to conduct civil proceedings on the protected party's behalf and to reimburse themselves from the protected party's funds. Now, that obviously isn't available in respect of a child, unless, again, they're likely to lack capacity when they're 18, in which case the Court of Protection would have power in relation to their funds. Right, so then turning then to compromise on behalf of a child or protected party. So once you've got through the proceedings and assuming that they've been successful, you've been successful in negotiating a compromise. No compromise on behalf of a child or protected party is valid without the approval of the court, and that's a blanket rule which is contained in CPR 21.10.1. So once you have your compromise, that compromise is not valid without the approval. And the way to get that approval is to make an application to the court. Now, if proceedings are already issued, then the litigation friend brings the application by application notice supported by a witness statement. That's an ordinary application notice. If they're not yet issued, which and you've managed to settle without the need to issue proceedings, then the litigation friend brings the application by Part 8 claim form. Again, it's supported by a witness statement, and that's CPR 21.10.2. Now, I'll go on to, there is some slight difference in the requirements between those two distinct sets of proceedings, and so I'll go on to discuss that in a moment. But the general rule is that until such time as a court's approval is given, any party, and that's not just a child or the protected party, can repudiate the compromise, and that's considered, and that's taken from Drinkall and Whitwood. Now, that's obviously can be quite, can be something, and it is something that has happened in cases with which I've been involved where consideration hasn't been given at the time of reaching the compromise to binding the other parties, because of course it's very frequently the case that after a long mediation you may well get a after a long mediation, the day after, sometimes people have buyer's regret. And you can draft the settlement so that you have a freestanding commitment on the part of the non-children and protected parties, so that it is binding on them, notwithstanding that the court hasn't yet given its approval on behalf of the child or protected party. And I think you're almost always, if you're acting for the child or protected party, very well advised to do that, because it means that you don't end up in what can be a particularly difficult situation, because obviously it can take and will frequently take weeks, if not months, to get the court's approval. Okay, then, so the application for approval, these do differ slightly, although in reality they don't differ that much, but just when you're ticking the boxes to what you need. If it's prior to the issue of proceedings, the application, the Part 8 claim form must be accompanied by a draft consent order. It must indicate, or the witness evidence must indicate, the extent to which the defendant admits liability. Now, of course, in our area of practice, or the area of practice which many of us will practice in, it's unlikely that's going to arise. That's really more towards professional negligence and personal injuries claims. The age or occupation of the child or protected party. You must, of course, indicate that the litigation friend has approved the compromise, because otherwise you shouldn't really be seeking the court's approval. And that does raise an important point, that it's not, what this is not, is a kind of surrender of discretion in the way that you might get with trustees or something like that. It's not asking the court to make the decision, it's asking the court to approve your decision or the litigation friend's decision. So really, if the litigation friend doesn't think that the compromise should be accepted, then that you shouldn't be making the application. But it's, the litigation friend does, can't just say, actually, I don't really know, this is too important. The litigation friend does have to say that this, I think this is a good thing. And of course, in doing that, they can, of course, rest easy in the knowledge that it won't be approved by the court, unless the court, agrees with the litigation friend. But nonetheless, the litigation friend has to make a decision in the first place. Then the other thing you need is a copy of any financial advice received regarding the compromise. That tends to be kind of IFA type advice or something like that about how you may invest it or something, or it could be. But in reality, that there often isn't any. And that's not a freestanding requirement to obtain financial advice. It's just if there has been financial advice, that should be included. And then this is a freestanding requirement. You need an opinion on the merits, which is from either counsel or a solicitor, and you need their instructions to be included, unless they're set out in the opinion. And usually, when I do opinions for these kind of things, I do set that out, particularly because it can just be kind of burdensome to have lengthy formal instructions to write an opinion if it's an ongoing matter which has been on foot for some time. And so all of that, as you can see, is found in Practice Direction 21 at paragraph 5.1, 5.2. Now, if proceedings have already been issued, then it's made in an application form, as I said, and you've got to have that opinion on the merits in the same way. Again, any financial advice, but again, not a freestanding obligation to obtain that advice, and a copy of any documentary evidence relevant to the opinion. So, for example, if there's been documents in disclosure or something like that, which the court may not have seen, then they should be appended to the witness statement in support of the application. And that's all from paragraph 6.4 of Practice Direction 21. So the hearing then of the application, it's not the case, as some people think, that there are no respondents to these application. It's the other parties to the claim or the compromise, if it's an unissued claim, should be listed as the respondents, or of course they're defendants if it's Part 8 application, Part 8 claim to approve the compromise. But note, of course, that what you're dealing with here are matters which are subject to legal professional privilege, and so they're not to be served with copies of the opinion or any other privileged information. You're not required to pierce privilege in order to make an application. Well, I suppose you're required to pierce privilege between the litigant, the protected party or child, and the court, but not as between the protected party or child and the other parties. And in the same way, consider redactions to the witness statement in support of the application. It may well be that you've been able to keep that short, but if you haven't, and there are privilege matters in there, then you should redact those before service on the other parties. And similarly, if the skeleton argument goes into a detailed discussion of the merits, or indeed any discussion of the merits, consider redactions there. Now, the respondents or defendants are entitled to attend. They very frequently don't, but as I'm going to discuss in a minute, depending on how tricky the compromise is, sometimes it can be in the best interest of the child or protected party for them to attend. But even if they do attend, they're not entitled to be present for such parts of the hearing as referred to privilege material. And what you might want to consider what you definitely want to consider is agreeing all of this at the outset as to how this is going to go. But unless the application is made during the course of the trial, in which case it will be the trial judge, then it will be heard by a master or district judge if it's made on behalf of a child, or a master or designated civil judge or nominee, if a protected party, and that's usually because the designated civil judge or nominee will also be a court of protection judge, although not invariably. So then, the hearing of the application, as I've already said, is likely to involve some pretty sensitive information and privileged information. So that raises the issue of whether or not it should be in public or in private. For that reason, and also for the reasons that, of course, it does concern vulnerable people in the form of protected parties or children. So the general rule is that at CPR 39.21 that the hearings to be in public, and there's no general exception to the rule for CPR 21 applications. However, 39.23 itself provides that if the court is satisfied that one of the matters listed in the subparagraph of that rule applies, and this is the point because some people sometimes miss this, it also, you can't just satisfy the rule and they're automatically get it. You have to satisfy the matters in the subparagraph of the rule and persuade the court that it's necessary to sit in private to secure the proper administration of justice. If you do, then it will do so. And the two that usually come into play in approval applications are that at 39.23c, which is that the hearing involves confidential information, including information relating to personal matters, and publicity would damage that confidentiality. And of course, it goes beyond confidential information in this case because you've also got privileged information, and that a private hearing is necessary to protect the interests of any child or protected party. And in my experience, the court will usually sit in private for at least those parts of the hearing that concern the merits of the claim, and as I said, also in the absence of the other respondents. But you do have to consider how much of the hearing does have to be in private, and if there are parts of the hearing, as there usually will be, that don't concern privileged or confidential information, then the court, strictly speaking, probably shouldn't be sitting in private for those parts, although in reality sometimes the court just sits in private because it makes more sense than private public, etc. But that will depend on the complexity, I suppose, and importance of the hearing. Okay, so the CPR 21 itself doesn't give any guidance as to the court's approach to the approval jurisdiction. And interestingly, the commentary on the White Book doesn't include any either, which is somewhat surprising. But again, what we're looking at, the best case to be looking at is the Bailey and Warren decision, which I also referred to earlier in relation to whether or not somebody is in fact a protected party. That was actually a retrospective application for approval of compromise, and that's clear from the judgment, and you do have to bear that in mind when you're reading some of the comments in there. But the relevant paragraphs are those at 180 to 84, and the principles which I've extracted from that are the following: that the court's discretion as to whether to approve a compromise is unfettered, and that what its role is essentially is to ensure the protected party's best interests, the protected party or child's best interests are served. And its first port of call in doing that will be to consider the advice, i.e. the opinion that has been provided as to the merits of entering into the proposed compromise. Now, so, you know, you're frequently dealing with judges, etc. And if that judge believes that the advice contains errors, that isn't necessarily fatal to the approval, because the court can still exercise its discretion to approve the compromise if it considers with the benefit of submissions that its terms are nonetheless reasonable. And it's very frequently the case that these approval hearings actually end up with just discussing with the court various aspects of the opinion and why it was felt that, you know, you didn't give more here or take more there or whatever. But in addition to that, in addition to the strict legal merits, as with other litigants, there are other factors which bear on the protected party's best interest in reaching a compromise. And these include, you know, circumstances in which it might be thought reasonable that you would accept a less favourable compromise in order just to bring the proceedings to an end, and also to avoid the risk, because it's all very well saying someone has a strong case, but of course you can't ever give any guarantees, and to avoid the necessity for trial, of course. And the Court of Appeal recognised that in Bailey and Warren in saying, you know, there are a myriad, I think was the word that they used, of factors which bore upon a compromise, and ordinary litigants are encouraged to compromise in civil litigation, and that in itself is a sufficiently powerful incentive that the court shouldn't readily question the proposed compromise on an approval application. So really that's the point, is that you shouldn't get a hostile judge saying, actually, I'm not sure about this. You really have to, unless they really aren't persuaded about the merits. But if they think that it's broadly okay, then you should be okay. And this is why I said that it can be helpful for the defendants or respondents to attend if it's quite a finely balanced compromise. You know, I mean, sometimes people are quite generous with protected parties or children. You get a compromise, you think, oh, this is great, and it's all very easy, you know. And in those circumstances, then it doesn't really matter if the respondents or defendants attend. But if you have a more readily, a more finely balanced thing, then the fact is that although it's the child or protected party's interests that predominate when the court's looking at the approval, it does have to take into account the interests of the other parties to the compromise. Because if an agreement was openly negotiated and concluded after protected party had taken legal advice, then that's a relevant factor. And the reason for that is because it's obviously not fair on the other side if after kind of, you know, a long mediation, you know, a set of proceedings where the protected party or the child has had benefit of legal advice and everything's been done in a way that it would be against an ordinary litigant, the court then says, well, actually, no, sorry, that's not good enough. Because from the defendant or respondent's point of view, of course, they should be able to compromise these proceedings in the way that they would be able to compromise these proceedings against another party. And so if the court's too parsimonious and doesn't take that into account when it comes to its approval jurisdiction, then you're essentially putting the other parties at a disadvantage because they're against a protected party or child. And that's why I said the interests of good administration of justice, including finality of judgments and the certainty of outcome, are also relevant. Although that tends to be that is slightly more relevant when it comes to this idea of a retrospective approval application, because in those circumstances, which is what Bailey and Warren were concerned with, if the court so actually no, it won't give approval, then, you know, and it was some years later, then essentially the other parties who thought that they'd had finality for those years are no longer getting that finality. One thing that was also said in Bailey and Warren is particularly, I think, in respect of protected parties, but also in respect of children, because it's a similar approach, is that you can consider the approach that the Court of Protection would apply under the MCA 2005, so the best interests approach, which is itself a more nuanced approach than simply, you know, is this the most amount of money that P could get? Now, this has started to cause more problems than it used to. in terms of the investment of monies that are recovered. Now, it may well be that you know, sometimes the approval or the compromise is reached without really considering what's going to happen to the money. If you've got a protected party, then that's fine usually. Well, if you've got a protected party who has a deputy, then it may well be that it's appropriate to just say, well, the deputy will give good receipt, etc. And as long as the court approves that, then that's fine. If it's a child, it's more difficult, particularly if there are conflicts of interest between the child, if it's a 75 Act claim or something like that, and their parents, you know, just saying, oh, it should be that they can give a good receipt. And possibly for those reasons, CPR 21.11.1 says actually, notwithstanding any terms of the compromise, or the court, the money recovered on behalf of a child or protected party will be dealt with in accordance with directions given by the court and not otherwise. And that is the case even if the protected party has a deputy appointed by the Court of Protection. And one of the things, it's almost seen, if you look at the structure of the rules, as the default position is that the court may direct that the money be paid in, the court may direct that the money be paid into court where it will be invested, or to the litigation friend for the immediate benefit of the child. But the second thing is actually quite rare, unless it's quite a small sum of money. Then usually you wouldn't just get the court blanket saying, actually, just go and spend it now. But one thing that you do get, particularly with, if you're in front of a judge who's unfamiliar with the way that the trust and estates work, works, then you will get this notion that actually the best way of dealing with this would be to pay it into court, which can be bad because well, is usually bad in my view, because A, it doesn't get a great rate of interest there, and B, it's very cumbersome to make any application to remove money from court. So it's very inflexible and can often be quite expensive. But one way that you can get around that is by getting the court to direct that the money is held outside of court on a bare trust. Now, theoretically, it can also direct a discretionary trust, but in reality, unless they're quite restrictive terms in that discretionary trust, the court's going to be quite hesitant to do that because, well, for obvious reasons, that if this money is supposed to be for the benefit of the child or protected party, then why isn't it done so? Because a discretionary trust would usually delay the vesting beyond 18. And it's often the case that litigation friends who are acting for a child don't think it's a good idea for a child to come into receipt of money when they're 18. And whilst that's understandable, the court doesn't have very much truck with that anymore. And you also see this now increasingly in respect of variation of trust things, that the court needs something more than a mere, it's never a good idea for an 18-year-old to have a lot of money in order to delay vesting beyond 18. So as I said there, if it is going to be a bare trust, then consider quite carefully the drafting of that trust, and in particular whether there's power to apply money for the benefit other than a minor, because if there is, then the court's going to need quite a lot of persuasion that that's actually in the minor's best interest. And who is to be a trustee? Now, if it's a large amount of money, as you can imagine, the court is much more likely to prefer a professional. If it's smaller, then it may well be more willing for it to be parents or guardian or family members. Usually the court will look for at least 2 trustees, particularly if there's any prospect that land may be bought with this for obvious reasons. But interestingly, the court doesn't usually require that it exercise the power of appointing new trustees. So, for example, these could be the initial trustees, and you know, if they were to resign or whatever, you don't have to go back to court for the court to decide the new trustee. It can just be dealt with in the way of an ordinary trust. And I think one thing that often bears upon the court agreeing to put it on a bare trust rather than in court is that, as I said, the rules are kind of heavily weighted towards personal injury and clinical negligence and that kind of thing. And that's the framework that they were drawn up on. But very frequently in these kinds of cases, if it's a contentious probate case or a family provision case, then the court respects the fact that the type of provision to be made for the child or protected party, it's often more appropriate that it be made in the way that it would be made in a will, because it's often the case that it should be used for the benefit of the child or protected party, and in the case of 75 Act claim, often just for the benefit of them while they're under 18 or 18 or tertiary education. So costs then, as I said, the general rule is a litigation friend can only recover the costs they've incurred on behalf of the child or protected party on application. And those costs must be subject to detailed assessment and are limited to the assessed amount. So unrecoverable costs are payable by the litigation friend personally. Now, that is problematic. And it's often the case that people haven't really given consideration to this, notwithstanding any gold-plated advice they may have received, until it actually comes to the compromise. And so I think you do have to think very carefully about the payment of costs when it comes to the compromise. And what you're looking to do is to bring yourself within one of the exceptions under Practice Direction 46, paragraph 2.1. And the four that are relevant for present purposes are these, where there's no need to order an assessment of costs to protect the protected party or the child or their estate. Now that's a kind of a sweep up category, even though it comes first. And in my experience, the court is not that willing to use it unless you've got very good grounds. So if there's lots of money, etc., or something like that, maybe. But even so, the court will usually expect one of the more specific grounds to be satisfied in order to depart from the general rule of detailed assessment. And the one that's very frequently used is where another party has agreed to pay a specified sum and solicitors and counsel agree to waive further fees. Now that's fine. So you basically, what you do is, you very frequently get a global figure from the defendant, and the defendant doesn't really care how you apply it. But it's important that when you draft the documentation, that it makes clear how much of that the defendant is paying towards costs. And so if it's the entirety of the costs, which it would have to be in order for the litigation friend not to be liable for anything, then that's fine. But that has to be spelled out in the documentation itself. And the legal representatives have to agree to waive further fees. Now that can be problematic in itself because, of course, if you're at a mediation, you've then got to do an approval application, which will cost money, and it can be quite difficult. So, but you can get around that by building in a contingency, as it were. And as long as you're upfront with the court, that still would bring you within the rule. And then where the court decided cost by way of summary assessment, and you've agreed to waive further fees, that in reality is unlikely to arise unless you specifically want to use it. So sometimes, for example, if you're settling rather than by way of a deed, or a Tomlin, but you're settling by, if it's 75 Act claim in particular, you're settling by just a straightforward order made under the 1975 Act, then you may well get the court to summarily assess the costs in the full amount at the hearing, and do that by consent so that the defendant is liable for them that way. So it has the same effect as the previous thing that I've just been discussing about. And where an insurer or other person is liable and the court is satisfied that they're able to discharge the costs, in those cases the court will say, well, actually doesn't matter, because as long as they've given you a blanket indemnity, then you're fine. But it's an increasingly vanishing number of cases in which that's the case. So as I said, all that should be considered before agreeing the terms of the compromise. And what if the costs are higher than anticipated? Well, in those circumstances, what you're looking at is you will have to build in that, or you could, in those circumstances, if it's not too much, if they're higher than anticipated, and you don't want to have to go back and redraft documentation, then you may get those under the no need to do so to protect the protected party or child's interests or their estate. Right, so that's the end of the talk. I've had a couple of questions which I'll just read now. I'm going to read these without so hopefully I'll be able to answer them because I'm about to read them out without having looked at them myself. So they're both anonymous. The first one is, in the case where a person agrees to become a litigation friend and undertakes to pay any costs ordered where P is a claimant, what protection can be afforded to the litigation friend for such costs? In many cases, P would have capacity to not want their litigation friend to be burdened by such an undertaking. So yes, if basically, as I said, there's two things there. So if you've got then a situation whereby you have somebody who is a protected party in the sense that they don't have litigation capacity, but they do have capacity to manage their own property and affairs, then there's no problem with that person, as long as they have capacity to do this within the context of managing their property and affairs, entering into an indemnity and indemnifying the litigation friend themselves for the costs in the proceedings. If they don't have capacity to manage their property and affairs, then you have to make an application for court of protection, and the court of protection can enter into an indemnity, can give you an indemnity. So that means then that any assessment gap or anything like that, that would be covered by the indemnity, either entered into by the protected party themselves or given by the court of protection on their behalf. And then someone said, how quickly are these types of claim being dealt with at the moment from an application to a hearing? That's a difficult question to answer. It's not the slowest at the moment, actually. I think I had one that was dealt with in the business property court, so in the Rolls building, the Chancery Division, that was dealt with in about 2 months, and that's not the slowest. If it's super urgent for any reason, then you can tell the court that, and they'll usually turn it around. Sometimes they take much longer than they should. I had one in the Central London County Court that took nearly 6 months, but that was just administrative errors and those kind of failings, which, you know, unfortunately we frequently encounter in the Central London County Court. But yes, theoretically, and sometimes they're dealt with more quickly if they are within existing proceedings, of course. And certainly if there's a hearing in the diary that you're about to come up against, you can generally just use that. You do have to be careful though, because of course, if, for example, there's any doubt about whether or not it will be approved, which I had the other day. I had one that was a little bit ropey, as it were, or borderline. And I think, you know, the opinion didn't say this was great. The opinion said this is probably okay, you know, just about. And so in those circumstances, of course, there's much more of a risk. And we were approaching the PTR pre-trial review, which was going to be heard by the trial judge. And of course, you have to be careful, because if a judge were to hear this application, an application for approval, and then didn't approve, they couldn't then be the trial judge. So in those circumstances, we had to be, and in the end, it ended up being heard on the same date as the PTR, but by a different judge. But you have to be quite careful, because, you know, if it weren't approved and we had to go to trial, which was not, well, which was more of a more likely outcome than would usually be the case, then you don't want to have kind of put the judge in a position where they're going to have to recuse themselves, because you'll just lose the trial date effectively in those circumstances, because it's similar to a bedo in those in that way. But yes, they're dealt with much more quickly if they're an interim application in existing proceedings, although not necessarily. It does very much depends on which master you get assigned to, and whether that master is willing to do it without a hearing, because I had he's retired now, but the chief master told me the other day that he never does an approval application without a hearing, but I know that some masters will do them without a hearing, and so that can speed things up. But yeah, if it's a standalone, then I think you are looking at months. But if there is a genuine urgency, then you can get the court to do that, to deal with it more urgently. Okay, well, I think we are, I don't have any more questions. And so I think we're pretty much bang on time to finish anyway. So thank you all for coming.